Hi, my name is Spencer Bienvenue. I'm a trainee solicitor here at Gherson Solicitors, working with the general immigration team. We are nearing almost the 2-year anniversary of the date of Brexit, and we are finding an increasing number of questions coming in relation to those who either hold status already under the EU settlement scheme, or for those few who, for whatever reason, have not yet made applications under the EU settlement scheme. For those who don't know, the EU settlement scheme was designed for a post-Brexit UK, specifically allowing EEA and Swiss nationals and their family members a means by which to secure their right to reside in the UK post-Brexit. Applications under the scheme resulted in two types of leave, or two types of status. The first being pre-settled status. Pre-settled status is specifically for those individuals who had lived in the UK prior to Brexit for less than 5 years continuously. This status resulted in a grant of a one-time period of 5 years of leave in the UK. The second type of status, settled status, or also known as indefinite leave to remain, was for those individuals, EEA and Swiss nationals and their family members, who had completed a continuous 5-year period of residence in the UK prior to the date of Brexit. For those who were making their first time applications under the status, the deadline for these applications was the 30th of June 2021, now just over a year ago. Despite this fact, the Home Office is still accepting certain applications for first-time applicants under the scheme. Even though they are late and would be submitted on a discretionary basis, theoretically one could still apply for settled status if they had completed a continuous 5-year period of residence in the UK prior to the date of Brexit as an EEA national or Swiss citizen, and since the end of their period of residency have not left the UK for 5 years in a row. So for example, if you say you're a French national, you moved to the UK in September 2014 and lived here continuously until September 2019, and since September 2019 have not been out of the UK for 5 years in a row, there may be scope for that person to make an application for settled status on a discretionary basis. It would inherently rely on the specific facts of each applicant, but theoretically there is scope to continue to make these late discretionary applications in that context. For pre-settled status, unfortunately, under the UK immigration rules, it is not possible to apply to extend one's period of pre-settled status or to reapply or make a fresh new application for pre-settled status. Pre-settled status results in a singular period of 5 years, a visa period of 5 years. The purpose of that was to allow people who hold pre-settled status to accumulate their 5-year period of residency here needed to then apply for settled status. The other part of pre-settled status, which is becoming increasingly pertinent, is that pre-settled status will lapse or cease to be valid if the person who holds it has been outside of the UK for 2 continuous years. Now, we're almost 2 years post-Brexit, so for those who may have been outside of the UK for prolonged periods of time due to national lockdowns, international travel restrictions, COVID-related illnesses, various reasons, they may find themselves with large periods of absence, be unsure if their pre-settled status is still valid, and be concerned about the knock-on effect of being eligible to apply for settled status. It's important, regardless, to begin planning ahead now, because it is not possible currently to extend pre-settled status or get a new grant of pre-settled status. Work needs to be done to preserve what the pre-settled status grant that you already have and make the best application possible for settled status when you become eligible. Firstly, ensure that you do not have a 2-year continuous period of absence from the UK if you hold pre-settled status. And secondly, if you do have prolonged absences, it is worth looking into the reason for those absences and planning ahead to ensure that the best case can be made for your eventual application for settled status. For those family members of EEA nationals or Swiss nationals that already hold status, it is still possible for them to make fresh applications under the scheme, and that is still operating as normal. Regardless, if you have any questions regarding the EU settlement scheme, your specific circumstances, and the status that you hold, please feel free to reach out to us. We'd be happy to review it with you. You can follow us on LinkedIn or Twitter or Facebook, or please feel free to email us or call us directly, and we'd love to hear from you. Thanks.